Boy, we have a special treat for you today. We have the world-famous Stephen Halbrook, Second Amendment guru and ATF guru as well, here to talk about what's going on with this pistol brace stuff that we keep talking about and everyone's concerned about. I can't think of a better man to talk to about this issue than Stephen Halbrook. Stay tuned. He's coming up just next. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. We want to learn from the mistakes that other people make, and I want to talk a lot about that in the context of the Ukraine situation, which we discuss in the book Disarmed. Check that out. All right, folks, welcome aboard Stephen Halbrook again. You're a friend of the Four Boxes Diner show. You've been on a couple times. Cannot thank you enough for coming back on. So this is a really important episode we're talking about because, you know, I don't consider myself an ATF guru or an FFL person. I don't represent FFLs or anything like this. But obviously this pistol brace thing is a really big deal. And it seems to me like a bunch of hooey in one sense that this is a power grab by the ATF trying to solve a problem that simply doesn't exist. And yet here we are on the eve, I think the deadline is May 31st, of potentially millions of Americans that followed the ATF's guidance, did everything what they thought was right and lawful, and now we may have millions of brand new felons in the United States, in just a few days. So first of all, what is going on with this pistol brace thing? And just kind of remind us what the issue is and where we stand.
Okay, Mark, good to see you again. Thank you for having me. The National Firearms Act restricts what we call short barrel rifles. That means any rifle with a barrel under 16 inches. And what's the definition of a rifle? It's a weapon that's designed, made, and intended to be shot from the shoulder. Very simple definition. Passed by Congress in 1934. It's been amended a little bit, but those three concepts have stayed the same. It's got to be made, designed, and intended to be fired from the shoulder. So along comes ATF, though, and decides we're going to improve on that definition that Congress set. We're going to say that pistol braces, if they are of a certain configuration that we'll have to figure out, they're short barrel rifles. Now, a pistol brace is simply a term meaning a pistol, not a short barrel rifle, not a rifle of any kind, with a brace on it that's designed to stabilize it. They're also called stabilizing braces. And so the way they work is you're holding the pistol and you have a brace that comes along the side, either on the top or the bottom, and it might have Velcro to attach to your hand. So if it's a heavy pistol, it helps you stabilize that pistol to hold it steady so that it's more accurate. So for years, ATF has approved these stabilizing braces as not being short barrel rifles, but suddenly in this new regulation, they decide, well, some of them we're going to reclassify as short barrel rifles, and some of them we're not. And it's really up to us, ATF, to decide which are which, because there's no clear guidance. It's how they're advertised, how they're designed, and the mindset of the ATF technology people who would pass judgment on them. There's a list of factors, but none of them are like objective factors, like Congress said, a barrel that's less than 16 inches. I mean, it doesn't get any simpler than that or more objective than that. So what we're dealing with potentially is because of this reclassification and the fact that short barrel rifles have to be registered under the National Firearms Act, something has to be done by May 31. And so there's 5 choices that ATF presents. One is that you can register it in the National Firearms Act. 2, you can get rid of the brace altogether and not just take it off like the director said in a congressional hearing the other day. Or 3, you can put a barrel on there that's at least 16 inches long. 4, you can turn it into ATF. Don't hold your breath waiting for people to do that. Or 5, you can destroy your whole weapon. Like, why would anybody do that? So that's what the pending issue is all about.
So Stephen, a couple things. First of all, there's been a lot of talk about this statement. I've heard a lot of people reach out to me, and that's a reason why I wanted to have you on to talk about this, because this is such a hot issue. Several other YouTube channels have talked about this statement made by the ATF director, Stephen Halbrook, about saying that, oh, you just have to take off the pistol brace from the pistol and that's enough, or something like that. Can gun owners, in your view, obviously every gun owner has to make their own decision. You're not giving legal advice. I'm not giving legal advice. Everyone has to consult with their own counsel and their own guidance because everybody's situation is different. With that said, though, can you take the word of the ATF director testifying in front of Congress as gospel as to what the law requires?
Well, Director Halbrook was flat wrong about that. It not only contradicts what the regulatory explanation says, it contradicts judicially decided cases. For example, it's been long the position, not just of ATF, but affirmed by courts, that if you have a pistol and you have a shoulder stock that fits it in your possession, and you can readily make it into a short barrel rifle, you've got a short barrel rifle. So it can be somewhat disassembled, but it still is a short barrel rifle. And I've litigated cases on this. One case went to the U.S. Supreme Court, Thompson Center Arms versus United States. We won that case, but for other reasons, because it was not just a pistol and a shoulder stock and nothing else. So I don't think the new director is particularly well versed about firearms issues, and he should have been better prepared by his staff when he made that, before he made that statement. We don't want to have people misled into thinking that all you've got to do is to remove the brace and you're clear. That's not what's going to happen. And if you're found with the brace, you're considered to be either an actual or constructive possession of it, of a short barrel rifle, if the two can be put together readily.
So let me and by the way, I want to remind everybody, for those very few people that don't know who Stephen Halbrook is, although I think everyone who watches this channel knows exactly who Stephen Halbrook is, the author of many books on the Second Amendment, and including The Right to Bear Arms and America's Rifle, basically the story of the AR-15 in the United States. If you haven't picked up America's Rifle or The Right to Bear Arms on Amazon, you should check that out. Stephen's most recent works, countless law review articles, and a successful litigant against the ATF in front of none other than the United States Supreme Court itself. So if anyone knows how to deal with the ATF, it's Stephen Halbrook, who's actually beat them in front of the U.S. Supreme Court. So Stephen is definitely the go-to guy on this. So with that said, Stephen, let me ask some very basic questions. So just definitionally, we all understand what a handgun is. And then a rifle under the law is a firearm with rifling that has a barrel of more than 16 inches. That's intended to be fired from the shoulder. Is that basically correct? As a general matter, the difference between a pistol, just a standalone pistol on the one hand, and a lawful non-NFA item rifle. How do I define those two terms? And then I want to talk about specifically the middle ground of this short barrel rifle concept.
That's correct. Pistol or handgun, they're not defined by the statute, but there's an ATF regulation basically saying it's a weapon that's designed to be fired with one hand. That said, it doesn't preclude the fact that we generally fire pistols with two hands because it's more accurate to do so. But at any rate, what you said is correct. A non-NFA rifle would be one with a 16-inch barrel, and once again, the definition, and it's a little bit even longer than I said, is made or remade, designed or redesigned, and intended to be fired from the shoulder. All three of those elements must be present.
Right, so here we are, we're living in a world where we know that handguns are, not only are you allowed to have a handgun, it's undeniably constitutionally protected by the Supreme Court's decision in Heller versus D.C. that said we have a right to a loaded handgun unlocked, ready for self-defense. So that's the handgun. We know obviously rifles, semi-automatic rifles, among other things, if you have a barrel more than 16 inches, that's undeniably protected under the Second Amendment. So all of a sudden, Stephen, it seems kind of weird that we have a short gun, meaning a handgun is protected. We have, long guns more than 16 inches are protected and perfectly fine. And somehow the ATF seems upset that people that take handguns, which are protected, and add this pistol stabilizing brace onto the back, and somehow that becomes a short barrel rifle that now needs to be registered with the NFA. And if you don't register it with the NFA, you get to go to prison. So why is the ATF doing this?
Well, they were ordered by the president to do it. This did not happen in previous administrations. In previous administrations, actually going back to the Obama administration, these configurations have been approved by ATF. Under the Trump administration, ATF continued to approve these configurations. By configurations, I mean the pistol and the stabilizing brace. It was not until Biden became president that the order came down to reclassify them. Why did he do that? Well, he's an anti-gun politician. It's a way that the anti-gun lobby has been demanding to try to get more and more firearms covered by the NFA or banned. And so it's pure brute force by the executive branch. I doubt ATF made this up. They don't make things up. They do what they're told. You know, it goes from the president to the attorney general to the ATF director and on down the line. And so there we have it. They're the ones out front, though. They're the ones who have to enforce this.
Yeah, in light of that, Stephen, so I just want to talk specifically about a couple scenarios here. And again, I understand you're not giving people legal advice. Everyone's going to have to make their own decisions with their own lawyers and their own counsel. With this said, one thing that struck me as kind of important for people to understand is, so let's say I went out there and I bought a pistol with a stabilizing brace, 5 or 6 years ago when this was perfectly legal. And let's assume, even for the sake of argument, it was one of the stabilizing braces that had been blessed specifically by the ATF, which I think there were some out there that had been. And that was, many years ago. And let's say I have this thing, and now I want to comply with the pistol brace rule. And I'm not going to destroy the weapon. I'm not going to turn it into the ATF. That would be silly. And I just decide what I want to do is to remove the pistol, the stabilizing brace, from that handgun, because the handgun still works. The pistol still works perfectly fine. So I just want to remove the two. It sounds like what you're saying, though, to be safe under the way the regulations are written, I can't just take the brace off and put it in like my living room and then put my handgun in like the bedroom, because you're saying that the ATF would likely take the position in law and in court that I still possess the pistol brace and I possess the handgun that goes with it, and therefore, because they're in my house, I'm still in constructive possession of a short barrel rifle that's not been registered with the NFA, and I can go to prison and be convicted of that. Is that true?
That's correct. You could go to prison for 10 years. That's the maximum penalty for an NFA offense. And the whole theory behind that idea, which really is contrary to the statute, but that's what the courts have upheld. There are some NFA firearms that a combination of parts from which an NFA firearm can be assembled is an NFA firearm. A machine gun is under that category, for example, as is silencer. Rifle is not. Shotgun is not. There's no definition of a combination of parts from which it can be assembled. But the courts have construed it that way, so we're stuck with that. And therefore, if you have a combination of parts, even though they're not attached together, if they're detached, as long as it's under your dominion and control, that's the key language. In other words, you have access to it, you can put it on the pistol, put the stabilizing brace on the pistol. If it's one that ATF considers to be a shoulder stock, then you're considered to be in possession of a short barrel rifle. So it's a combination of, I think, a misinterpretation of these statutory definitions, but it's stuck because that's the way the courts have so decided. So we're left with that, and so we've got to abide by that construction. And therefore, if you have the brace, and if it's something ATF would consider to be a shoulder stock, your best bet is just to get rid of it altogether, unless you want to go the route of registering the complete weapon or one of the other options.
So, one of the things we do on this channel is we try to get into some of the super geeky details and be very precise. And something you've said, I think, is mission critical that I just heard, Stephen. It sounds to me as you're saying that in the context of NFA items that are a suppressor or a machine gun, those definitions are broader than a short barrel rifle, because the definitions of what a suppressor is and a definition of what a machine gun is includes parts that make up those items, but that language of parts that make up those items that language does not appear in the definition of short barrel rifle, which is yet another type of item that falls under the NFA. But the reality is, what you're saying is, despite the fact that the Congress's statutory definition is broader, including parts that make up a suppressor, parts that make up a machine gun, falls under the statutory definitions, which is not there for the short barrel rifle. But you're saying, as a practical matter, it doesn't matter because the courts have allowed the definition of short barrel rifle to include parts that make up a short barrel rifle in a sense. So the courts have essentially broadened the scope of the statutory definition beyond what Congress did. Am I basically understanding that correctly?
Yeah, you're correct. Look, the rifle definition is fairly simple. It's a rifled arm, and it's got the design made and intended to be fired from the shoulder, or one that can be readily restored as such. That way, if it has a broken firing pin, it can be readily restored, so it's still a rifle. But when you get the machine gun, it's a weapon that shoots, is designed to shoot, or can be readily restored to shoot more than one shot automatically by a single function of the trigger. It includes a combination of parts, or a single part that would be used to convert it into a machine gun, or a combination of parts from which a machine gun can be assembled when possessed by a person. So what a contrast. How much broader is that definition than the definition of rifle? But that's the way courts have gone with it. So what we end up with is usually a combination of parts. If it can only be assembled as a short barrel rifle, would be considered as a short barrel rifle. But that's where our Supreme Court precedent came in. If you could assemble it as a long barrel rifle and as a regular short barrel pistol, it's not a short barrel rifle, even though you could assemble it as such. And that's the Thompson Center Arms case, and that was decided based on the rule of lenity under which we construe statutes, criminal statutes, narrowly against the government and in favor of the individual.
Well, I think that's an important thing to talk about for a couple minutes here. And frankly, Stephen, I think you are far more accurate and precise in how this is used than even many federal judges that get it wrong. It's not unusual to see federal judges, even the smart ones, get things wrong. So let's just clarify the Chevron Doctrine and the rule of lenity, and then let's apply to the context of this pistol brace dispute. As I understand it, correct me if I'm wrong, thanks largely to your excellent work in the Thompson Center Firearms case, which you won before the United States Supreme Court, if you're dealing with a regulation or a law that has criminal components, meaning you can be convicted of a crime and go to prison. It's a criminal case. The rule of lenity applies, and that rule of lenity basically says that if you have multiple reasonable interpretations of that regulation or of that law, that statute, the tie, in a sense, goes to the law-abiding citizen. In other words, all the ambiguities are construed against the government in favor of the citizen because it's a criminal case, and if Congress hasn't written the statute or the ATF hasn't done their job right, then law-abiding Americans should not be punished, the government should be punished, and freedom should prevail and not oppression. Did I basically get that rule of lenity correct?
That's correct, and it's really based on the due process clause. The person should not be deprived of liberty without due process. If the law is unclear, it's a rule of construction that goes back for hundreds of years in our Anglo-American jurisprudence, that if it could go either way, and it could arise in a civil case as well as in a criminal case, as long as it's a statute with criminal implications, you have to construe it in favor of the citizen and against the government. And that's why this so-called Chevron deference doctrine that the government always appeals to, I like to call it the divine right of deference, because it harkens back to the idea that the divine right of kings. The government comes into court and they tell the court that, well, you should agree with our interpretation because we're the government. Think about the audacity of saying that when courts are supposed to decide the law. And yet courts, based on this so-called Chevron doctrine, have been allowing the executive branch to tell the judicial branch what the law means, the law that Congress passed. And so you also have the idea that has been set forth in a number of Supreme Court decisions. We should never defer to the government as a general mind, Chevron or no Chevron, in a criminal case. Why would we defer to the government's interpretation when the government is prosecuting the case? I mean, why would you take one legal team's analysis over another legal team's analysis? That's what judges are for. They're supposed to be neutral. We want to interpret the law, and if the law is ambiguous, we need to interpret it in a way such that it doesn't apply against a citizen. You know,
it's very interesting, Stephen. I think just to break it down for the viewers, some of the stuff we talk about is extremely detailed. It's extremely geeky. But at the end of the day, it really, in many respects, is simple when you break it apart and really kind of look at things in its component parts. And if you think about the Chevron deference doctrine, or the divine right of deference, I like that. Think about it. Just step back for a second to like a high school civics class. The three branches of the federal government work as follows, right? This is the basic rule. Congress makes the laws. The executive branch, which is the president and the agencies that work for the president, they enforce those laws that Congress makes. So Congress makes the laws, the presidency and the executive branch enforces those laws, and last but not least, it's up to the courts, the judiciary, the third branch of government, to interpret those laws giveth from Congress. And it sounds like what you're saying with this Chevron deference doctrine that's been with us since, I think, the 1980s. Basically, it's allowing the executive branch, the presidency, to not only enforce the laws, but also to interpret those laws rather than have the courts do it. It's crazy that would be the situation, but that's kind of where we are with the Chevron doctrine, isn't it?
That's where we are. And keep in mind, the executive branch has been usurping power from both the legislative branch and the judicial branch, because these agencies have gone wild. They have over and over taken what's been delegated to them and played it up to be a lot more, like we had the EPA versus West Virginia case for the Supreme Court in the major questions doctrine, slapped that down somewhat. There's a case in the Supreme Court coming up on the Chevron doctrine in general, where an agency said that we are going to be inspecting fishermen and we're going to make them pay to be on their ships while we're doing so. And there was nothing in the statute that Congress passed to allow them to do that, but they just usurped, they grabbed that power. And so then when you get to court, after they've taken that power from Congress, now they try to take another power from the judicial branch and say, hey judge, we decide what the law is, not you. And so you have to defer to us.
Stephen, I was thinking, there is this case coming up to the United States Supreme Court dealing with the Chevron doctrine. So, and it specifically in the question presented, the question that was presented and the cert was granted by the U.S. Supreme Court on the question of whether or not the Chevron doctrine, which again, the Chevron doctrine just basically says that you trust the government to interpret the laws correctly, and the courts don't really get a same crack at it. The question presented in that Supreme Court case is, should the Chevron doctrine be, thrown into the trash bin of history, which is pretty good signal that it's going to be next term, but only time will tell. Hopefully that is, because that does allow that executive branch, the presidency, to usurp all this power. So every time, a government agency on behalf of the federal government writes a letter to an FFL or to anyone, this is not just the gun industry, this is the whole country, like, companies that are regulated by the FEC or by the SEC, it doesn't matter. They just cite the Chevron. So, hopefully we get some cutback in that power. By the way, Stephen, what does the bump stock victories that we've seen in some of the lower courts in favor of declaring that the ATF overstepped their reach in the context of defining bump stocks as machine guns, will those precedents be potentially helpful in the litigation over the pistol braces?
Yes, they will be, Mark. And let me just add a footnote about Chevron. The first step in the Chevron doctrine was that if the text of the statute is clear, that ends the matter. There's no deference. And if it's not clear, you go to step 2 and you defer. But that first step also is one that has been watered down, because the courts say, well, what the heck, we don't have to decide whether the statute is clear cut. We'll just affirm what the agency says. So the doctrine has actually been very misused. But yes, these two cases, the Fifth Circuit case where you had an en banc decision by the full court, so it's ended at that court. There's not going to be anything further. All the judges, a majority of the judges, have said that this ATF regulation is invalid. What the most judges, I think there were 12 of the judges, agreed to was that the rule of lenity makes clear that this regulation cannot be. And then you have some judges who take the bull by the horns and say, looking at the definition, it does, and of course this is the definition of machine gun we're dealing with now. It just doesn't fly that a bump stock, because you have to use a manual movement, which is keeping forward pressure on the forend or the front of the stock when you're firing. That forward pressure means that it's not firing automatically more than one shot by a single pull of the trigger. So, and then you have the Sixth Circuit, a 3-judge panel holding and agreeing with the Fifth Circuit. So that's where it stands. The only way this is going to get resolved is for the Supreme Court to resolve it. What they could do is the case they have now involving the fishermen. They could decide that and then send the bump stock cases back down until the courts now resolve this in light of our new decision. Because if they do away with Chevron, or if they greatly water it down, that's going to be a whole new ball game, and I look forward to that new ball game.
Well, Stephen, one thing about this, because I don't have any pistols or pistol braces myself. With that said, though, if I were to have a pistol with a stabilizing brace and I was trying to figure out what to do, it seems to me, and I'm speaking hypothetically here because I don't have to do it, but it would seem to me hypothetically the easiest solution would be to remove the stabilizing brace, and get rid of the brace somehow. Is that that, or I guess put a new barrel on the pistol? But I don't know. It seems like the easiest thing for most gun owners who are paying attention. I bet there's millions of gun owners that aren't even following this, because a lot of gun owners, buy stuff, they hold on to the stuff, they keep it in the closet, maybe they shoot it every other year. There's a lot of people like that. I bet there's millions of people that won't even know that they have something they're not allowed to have, and how would they know? So I guess the question is, when you say you can't just take the stabilizing brace off the pistol, Stephen, and stick it in a closet, that's not good enough. What do you do actually in the real world, would you say, with these braces? What does a person actually do to have to get rid of it? Do they have to burn it up, throw it out in the trash, or what do they do in the real world?
Well, to your point about a lot of people not even knowing about this, the proposal and then the final regulation, did that take over 100 pages in the Federal Register? I think it did. And then this is technical stuff, and then ATF says that if you really want to know whether we consider it to be a stabilizing brace or a short barrel rifle, you have to send it to us. And then you go on this wait list, and it could be in their hands for evaluation for who knows how long. It could be a year or more. And all the while, you don't know what it is until they tell you what it is. And that's one more reason why this is just not right. You can't tell people that, well, we, the government, will tell you whether what you have is legal or not. So if you're really keen to all of this and you want to register it, you could register it, and then you could put a real shoulder stock on it, and you could have a real short barrel rifle tax-free, because you're not going to be paying the $200 transfer tax. So that's another option. And then I don't know how realistic it will be to put a 16-inch barrel on there, because that's going to really be top heavy, front heavy. And it might make it very difficult to fire, and it might not meet your needs. You might keep it for self-defense, or you might in the home, or maybe in a truck or something. And with a 16-inch barrel, that's a game stopper. So I'm sure there's a lot of rumors going around. Also, anytime there's something like this, there's people who maybe know about it, but they don't want to get in compliance, and you're just taking chances. And look, we shouldn't have to live that way as free American citizens, where you think something's a government edict is illegal, but they're bigger than you. They have, all the bodies of armed men to come and take you away if they find you to be in what they consider to be in violation. So what you have to do is go with the flow and get into compliance, and then wait and see what the courts are going to do.
Yeah, it doesn't seem to me, the prosecutors, the federal prosecutors, they get to pick and choose who they target. So I'm guessing, just as my speculation, but I think it's a reasonably best speculation, that they're probably not that keen on American gun owners. And if they have an opportunity to get a gun owner to get a felony conviction on their record. They might not even put you in prison. They just want to turn you into a felon, which prevents you from having guns for the rest of your life, at least under the current law. Maybe that'll change with the Range case out of the Third Circuit, but that we're getting ahead of ourselves. I think it's a big danger. And, the other thing is, people get divorces, people get into feuds with family members, and you don't know, even if people think that maybe you've got something hidden away in your house or something, you don't know who else is in that house that may want to call the government on you. So, people got to be real careful and make sure they comply with the law. And again, Stephen and we can't give people specific legal advice here, but people want to really make sure they do what they need to do to comply with the law because, American gun owners, I don't think are, looked at favorably by this administration, by the Department of Justice right now. And if anyone, lets them know that, you may have something that you shouldn't have, I'm guessing that there's a great chance that the feds will be showing up and knocking at your door. I don't know why they wouldn't in today's environment. But that's just my best sense of it. I don't know if you have a thought on that, Stephen, because you're closer to all this than I am.
Well, number one, I'll say, in a good word for some prosecutors, they're not all like that, although they do think they have to do their job. Not every prosecutor is anti-gun. There are plenty who are. But this has always been a problem with most provisions in the Gun Control Act. It has to do with victimless crimes, and these are cases that are easy to make. If you've got a burglary or a blue-collar crime, or you have fraud in some fashion, some kind of banking issue, it might be a lot harder to make a case. But in the case of the National Firearms Act, it's easy to make cases. You've got the fact that if it really is a short barrel rifle, you measure the barrel, and if it's less than 16 inches, you're fried. And so prosecutors like to keep up a batting average. These are easy cases to make. But what's not going to be easy, though, in this case, is intended to be fired from the shoulder. Whose intent would that be? Would it be ATF saying that's your intent? How do they know your intent? And we've got the Staples case from the U.S. Supreme Court saying that knowledge is an element of the crime. So that for the government to prove that this is a short barrel rifle, they also have to prove that you know it to be a short barrel rifle as defined. You don't have to know that it's under a criminal law, but they do have to show that you knew that's what it was. And that's going to be very difficult to make if it's got a stabilizing brace on it, and it's particularly if it's one that was approved by ATF, and then later they flip-flop and say, oh no, it's a shoulder stock, and therefore this is a short barrel rifle. That's going to be a difficult element to prove.
Yeah, I agree. You're right. It's on the one hand, it's a very easy case for the prosecution to prove at the first instance, because you're right. What do you really need? You need a single witness. You need somebody from the ATF. You put them on the stand. You introduce the alleged short barrel rifle into evidence. You have that ATF agent measured in front of the jury and say, yeah, it's too short, and this is the gun, and I found it in his closet in a search. It was lawful, and that's the whole case. There's no he said, she said. It's very, very easy. But you do raise a good point. There's some other, ambiguity with some of the stuff about intent and whatnot. Now, so that gives rise into a related question, Stephen, and I appreciate you taking the time. We'll wrap it up in just a minute here. But what if the whole idea of these stabilizing braces initially was to help disabled veterans, disabled people that did not have strong hands, they were getting older, maybe they suffered an accident, and it was allowing them to exercise their right to keep and bear arms under the Second Amendment so they could hold a handgun with one hand with a stabilizing brace to defend themselves and their families in a way that, people that could do if they have two fully functioning hands and arms. Not everyone has that. So what happens if you literally have a undeniably disabled person, with notes from the doctor, a record of having, injuries or their amputees, whatever it is, a clear case of someone that's disabled? What do they have to do? Do they have to give up their stabilizing brace as well, or what do they do? There's no Americans with Disabilities argument here because that act doesn't apply here. So the question is, if you're legitimately disabled, you're a Vietnam War veteran or an Iraq veteran with problems, How do you think about that in that context, Stephen?
Well, there's a silvery worded paragraph in the explanation to the regulation by ATF, which is really deplorable, I think. They address what if a person is using one of these stabilizing braces, they have a disability, and it's like, oh, if you like your insurance, you can keep your insurance, because ATF says to that, well, if that's really the case, then it's not a short barrel rifle, but it still has to be designed in a way that it's not a short barrel rifle. So that didn't give you anything. That doesn't give people with disabilities anything. The bottom line is ATF will still decide whether that stabilizing brace on a pistol makes it into a short barrel rifle or not. So it was an unfortunate statement to even make, but it was an attempt to try to address the fact that the original approval letter by ATF had to do with was addressed to a manufacturer who wanted to make these and who was a veteran, and who specifically said in the letter, the application basically, that I want to make them for veterans with disabilities.
Well, Stephen Halbrook, I appreciate your time. I'm going to talk in a separate video for those viewers out there about the status of some of the litigations that may influence this. But as of now, as best I can tell, Stephen, the regulation is going to be fully effective. The grace period, if you will be over on May 31st. That's coming up in a few days. And then the regulation is the regulation. It's on the books. It has to be complied with in all respects. And there's no more kind of window of grace or anything like that. Is that fair to say, absent some court decision, which hasn't occurred yet?
Yeah, and I recommend everybody get into compliance in plenty of time. Don't wait till the last minute. You might want to register it. Well, do it as soon as possible. Don't wait till the last day. The system might crash. Get rid of it if you're going to get rid of it. Do it now, because you might be doing something else that day and then forget about it, or something interferes. So the day's coming. None of the lawsuits, I think there's 5 of them that have been filed, have been able to generate a preliminary injunction or anything against this. So we'll keep an eye on what the courts are going to do. But as we know from other kinds of litigation, like the Illinois assault weapon ban, for example, you might end up with courts going different ways, and you don't know which guidance to take. So just go ahead and get into compliance. Wait it out. Let's see what the courts are going to do, and hope for the best.
Got it. Well, Stephen, I guess my last question then is, for those people that want to be in compliance and they just want to remove the pistol brace and get rid of it, what do they do with the brace after they remove it? If they definitely want to make it undeniably clear that they no longer possess the pistol brace, the stabilizing brace, they've removed it from the pistol, now they have it, should they literally throw it away? Should they give it to an FFL? Should they turn it into what should they do to get rid of this so they can never be accused by the ATF or the Department of Justice or anyone that they have a short barrel rifle that's not registered by the NFA or registered with the NFA with a 10-year penalty? What is the cleanest thing for them to do once they remove that stabilizing brace from the pistol?
Well, whether it's throwing it away in the garbage or in a lake or whatever you do with it, the bottom line is you cannot have the ability to exercise dominion and control over it. If you give it to somebody, they can't give it back. That's got to be a clear understanding. You could send it into the National Repository of Stabilizing Braces. That's a new division of ATF. And you can give it to a museum as a collector's item. I'm sure this will be a hot item for them. No, seriously, it's like the best thing. I mean, you can cut it up. You can cut the part off that attaches to the pistol so they would not attach, and then you can mount it as a display on your wall as a tribute to something or another. A conversation piece, and that's it. You just get in compliance. That's what I think the bottom line should be.
Right. So the bottom line is you just got to get rid of that pistol brace. Again, that's a way of doing it. You can register it with the NFA. There's other things that can be done. But again, from my point of view, if I had one of these things, I would hate to do it, of course. but I would, I would take it off the pistol and then I would, throw it away or get rid of it. So I could not. I would make sure that no one could say that I had control over it in any respect, because it's just not worth the risk, unfortunately. Now, it's terrible and stupid and in many respects just horrible, but this is the world we currently live in, and I don't think this is the hill to fight on and die on, from my point of view, if you're an American gun owner. There's other bigger fish that have to be fried than this one, but that's just my opinion. I don't know if you have a final thought on all this, Stephen?
Well, we live in a world that's always changing, but one thing is always the same. You've got ruler versus ruled and liberty versus slavery, the oppressors versus the oppressed, and the pendulum swings back and forth. Governments like to disarm people so they can control them. We've been very fortunate in America to have our Second Amendment and to have the blessings that we do, that things haven't gone further than they've gone. You compare our situation with some of the other countries in the world, we're in a very good situation. But the bottom line is you need to know what your rights are and be prepared to defend them and vote for the right people, and let's move on. This fight will always go on. It started in ancient Greece and Rome, or before that, and it'll always continue.
Yep. And freedom is not free. We always have to fight for our freedom, and it's not a new phenomenon. And that fight will continue long after, I'm sure, we've moved on into to heaven or wherever people move on to. So, all right, Stephen. Well, thank you very much, Stephen Halbrook, author of The Right to Bear Arms, author of the AR-15 book, America's Rifle. Check it out on Amazon. Stephen, thank you so much for joining us, and we look forward to talking to you again soon.
My pleasure, Mark. Good to see you.
Orders up. Table 2A.